Hello and welcome to the Hammond Iles Financial Power Hour, where each month we tackle an issue to make sure that you're an educated investor, to make sure that we create a clear path for a purposeful life. And today we're joined by a special guest, Attorney Joan Reed Wilson, and we're going to talk about the myths and misconceptions of Medicare and Medicaid. This is an issue that will impact all of us, whether that is currently that you're on Medicare, or you have a parent on Medicare, or may someday be on Medicare yourself. And hopefully, if you do need Medicaid, that you can do some planning to protect your assets from long-term care costs. And today we're going to clarify the difference and the misconceptions between those two so that you can better plan to protect your assets. Now, before I get started, I'm reminded of a joke of, do you know what health insurance Moses would have if he were still living today? Well, it was Medicare Part C. Well, to start off, I just want to let you know that Hammond Iles Wealth Advisors is a registered investment advisor. We do not provide tax or legal advice. And so as always, we encourage you to consult a legal or tax advisor to be able to give you advice on your specific situation. Today, we are going to talk about potentially Medicare and Medicaid from the perspective of being in the state of Connecticut. But certainly a lot of these rules apply across the country, but we encourage you to get advice for your own particular state related to your specific situation. Well, today, as I mentioned, we're delighted to have a return guest, Attorney Joan Reed Wilson. She is the managing partner of RWC LLC, Attorneys and Counselors at Law, where she practices in the areas of estate planning, elder law, Medicaid planning, conservatorships, probate and trust administration, and real estate. She's admitted to the states of Connecticut and California, and she is the president-elect of the Connecticut chapter of the National Academy of Elder Law Attorneys. She's also an active member in the elder law section of the Connecticut Bar Association and is accredited with the Plan of Connecticut for pooled trusts and with the Veterans Administration to assist clients in obtaining aid and attendance and benefits for long-term care. We're very grateful to have Joan Reed Wilson join us again on our Financial Power Hour. She's also been a guest on our podcast, Your Money, Your Purpose, and you can listen to those recorded episodes on our website at hiwealth.com. So without further ado, thank you, Joan, for joining us, and I'll turn over the floor to you to share those myths and misconceptions of Medicaid and Medicare.
Thank you so much, Greg. I'm so happy to be back and happy to see so many people interested in learning about this. So hopefully you'll get something out of it. As Greg mentioned, I am an attorney in Connecticut. So a lot of what I'm going to be talking about is specific to Connecticut. But the Medicaid and Medicare programs are obviously a federal program. So there is a lot that you can learn even if you're not in Connecticut. But you should speak to somebody in your own state for the specific details. But hopefully this presentation will give you some information. So I've been practicing for 26 years now, and I prepared this presentation. I've given it previously. It's based on all of the misinformation that I hear from clients when they come in and they talk to me about their own long-term care. So that's where it kind of developed from. There are 10 myths and misconceptions that I'll review today and kind of go into detail about what the real story is. And when I started giving this talk, it was pre-2020. We used to do everything in person. People were able to raise their hands and ask questions. I'm happy to have you put questions in the chat because I'm here to educate you. So if you have questions that I'm not touching on, please feel free to put them in the chat, and I think Greg will be able to let me know if there's questions in there. So I'm going to share my screen so we can go through the presentation. Everybody see that?
Yes, yes, we do.
Great, thank you. Now I have to figure out how to move it. There we go. So starting with myth number 1, the myth is that Medicare will pay for your long-term care, such as an assisted living facility or a nursing home. So Medicare is a health insurance, essentially. Once you turn 65, you're eligible to get onto Medicare. Sometimes people who are under 65 are also on Medicare. If they have been disabled for 2 or more years, they can be eligible to get onto Medicare A and B, which is the health insurance that pays for hospitals and doctors. But it does not pay for continuing long-term care. There actually has to be a medical need for Medicare to pay for that sort of health care. And I think where sometimes the misunderstanding comes up is people might go to the hospital. Somebody who's over 65 might be admitted to the hospital, and Medicare will pay for that hospital stay. And then oftentimes if you stay in the hospital for a period of time, because you've been sitting in the bed for a long time, your body gets weak, and the advice of the medical professionals is you should go to a nursing home for short-term rehab to get your strength back up, and you have physical therapy and occupational therapy to get your strength back up. And that portion of the nursing home stay is covered by Medicare in most cases. So I think that may be where people think that Medicare is going to pay for a nursing home. It doesn't pay for that nursing home stay after a certain period of time, and it's a very short period of time. And it depends on your Medicare program. So it can pay anywhere from a couple of days up to 100 days is the max. But it really depends on the program you have for your Medicare and what your actual needs are. So once the medical professionals or your insurance program determine that you do not have a skilled need anymore, then they're going to say, okay, Medicare is not paying anymore. You and your family might feel like you would benefit from more care or staying in the nursing home for a little bit longer. And at that point, you would have to start paying privately out of your own money, or potentially switch over to the Medicaid program, which would help pay for your nursing home if you meet certain income and financial asset requirements. So myth number 2 is if I transfer my assets to my spouse, I can qualify for Medicaid because the assets are not in my name anymore. So as I mentioned, Medicaid is the program that can pay for continuing long-term care, but there's income and asset qualification requirements. Medicaid will pay for someone's care if they are under a certain income threshold and under a certain asset threshold. The way that Connecticut calculates if someone qualifies for this Medicaid program is they look at all of their assets, and if they're married, they also look at all of their spouse's assets. So it doesn't matter if the assets are all in your name or all in your spouse's name or all joint. Connecticut just adds them all up. They look at the couple as one unit before they qualify for Medicaid. So you can't just take assets and put them in your spouse's name and then apply to the state and say, okay, I don't have any money left. Can you please pay for me under the Medicaid program? Because the state is going to make you calculate everything that is in your spouse's name as well. Myth number 3 is I'm allowed to gift $15,000 per year to my children without penalty. And this is a big one. I hear this almost every day. And where the confusion comes in is there is a gift tax exclusion under the estate and gift tax laws for the IRS and for in Connecticut, the Department of Revenue Services, that says you can gift a certain amount of money to someone else and not have to even report it. It's excluded for gift tax reporting. Currently, it's actually 17,000, but a lot of people think it's 15 because it was 15 for a while. Some people still think it's 10,000. So it's a little bit higher than this, but it's not excluded for Medicaid purposes. So when and if you are paying for a lot of long-term care that Medicare is saying we're not going to pay for, it's not a skilled need. Maybe you have someone who needs to come into the house to care for someone who has dementia, or you have mobility issues, and so you need somebody to come in and help you get up and transfer from bed to the wheelchair, or you need somebody to come in and help you with personal needs, and none of it is considered a skilled need like physical therapy or occupational therapy. So Medicare says we're not going to pay for that. It's not skilled. So then you start using up your own money and you think, well, I'd like to apply for Medicaid to help pay for this. When you apply for the Medicaid program, the state looks back 5 years and they want to know, why don't you have any money? Why are you coming to us and saying, can you please pay for my care? State, I don't have any money left. So they want to look back and make sure that you didn't just give away all of your money. If you gave away $15,000 per year to each of your children and each of your grandchildren in that 5-year history, the state's going to say, well, we don't want to pay for you. You just gave away your money. Get it back from those people you gave it to, and then you can pay for your own care, and then come back and ask us to pay for you. So the state, for Medicaid purposes, doesn't care that it was excluded for gift tax purposes. So this is a real problem for a lot of people who believe that the gift tax exclusion also allows them to gift this amount of money and be excluded for Medicaid qualifications. Myth number 4 is I reviewed all of the Medicare options when I retired, so I don't need to review them again. And this is something that I hear a lot from people, and they might come into my office, 15, 20 years after they signed up for Medicare, and they didn't realize that they can review and change that plan every single year. And why it's important is because your care needs change, your health changes from year to year. So you want to make sure that whatever insurance program you are signed up for is going to meet those needs, specifically with regard to medications. A lot of times, the particular insurance company that you might have chosen for your Medicare Part D for your pharmaceuticals drops a drug that you absolutely need, and you're going to be paying out of pocket because the insurance isn't paying for it anymore. Or you might sign up for a program because you're healthy when you first sign up for Medicare, and you have a very low premium but a high deductible, and then you get news from your doctor that you're going to have an expensive surgery. So it might be better to be on a program that has a higher premium but a much lower deductible or copay. And the Medicare program, anybody who's on Medicare has the option to review and change the plan they're on every single year. The Medicare companies, the insurance companies that offer the Medicare options, also change every year. So not only is it necessary if your circumstances change, but it's really a good idea to review it even if your circumstances haven't changed, because the program that you were on may have changed. And I don't do Medicare. I'm not a Medicare agent, but we have a lot of Medicare agents who we refer to help people through this process. They do not charge for this service. So it's not like you're going to be paying a lot of money for someone to review your Medicare plan. They get paid, by the insurance company that they choose for you. So you just want to make sure that you go to somebody who's reputable and trustworthy, because you don't want them choosing a plan because it's going to be a higher commission for them. You want to make sure that they're going to choose the right plan for you. So this is what's known as the open enrollment period, and that's generally between October and December. So it's something to kind of be preparing for. Maybe reach out and try to find an agent who might be able to help you just review. The other thing to keep in mind is with married couples, you don't have to necessarily have the same plan. So you can review that every year. And I would advise everybody to do that. Myth number 5 is that when my spouse or I am placed into a room at the hospital, as opposed to the emergency room, we have been admitted to the hospital. And this was a big issue that came up probably about 6 or 7 years ago. People were going to the hospital, and as I mentioned earlier, the hospital is covered by Medicare. So you go to the hospital, Medicare is paying for it, and then oftentimes the hospital is recommending that you go to short-term rehab to get stronger once you've been in the hospital for a little while. And that short-term rehab stay is generally covered by Medicare. What was happening is people were going to the hospital, staying for 3, 5, 7 days, a good amount of time, and then the hospital or the medical professionals were recommending go to a nursing home, go to the short-term rehab, get your strength up. And the family was taking that advice and bringing the person to the nursing home. And the nursing home would say, please pay us $7,000. And it was just a shock and a surprise to people who would bring their loved one on the advice of the medical professionals that all of a sudden they're going to have to cough up $7,000. What was happening was the stay in the hospital, the person was actually not, quote unquote, admitted. And that's one of the requirements for Medicare to pay for short-term care. The person who was in the hospital, even though it was for, a lengthy period of time, could have been a week or more, was only in there under observation. But the person didn't know that, and the family didn't know that. It was just, something on their chart that was documented. And because they were only in the hospital under observation, it didn't count as a qualifying stay under Medicare rules. And so Medicare said, well, that wasn't a qualifying stay, so we're not going to pay for your short-term rehab. And since it came out and it's people are more educated about it, it's gotten a little bit better. There's not as much of that shock because a lot more people are aware that this could be a possibility, that they're only under observation in the hospital. So they ask the question. They know to ask before they show up at the nursing home. But it is still something that's happening. The reason behind it was hospitals were getting financially penalized from Medicare. If somebody showed up at the hospital and Medicare paid for them to be in the hospital, and then the hospital discharged the person, and then the person came back to the hospital for the same thing, whatever was causing them the hospitalization in the first place. Medicare was saying to the hospitals, we don't want to pay for these readmittance. Figure out what's wrong with this person and take care of them. We don't want them to come back into the hospital and us to have to pay for that again. So, a lot of times the hospitals, they can't figure that out. Medical is not necessarily an exact science. So in order for the hospitals to be financially protected, they said, well, if we're only going to get dinged financially if it's a readmit, then we're not going to admit this person in the first place. Because if we discharge them and then they come back, it's not a readmittance because they were never admitted in the first place. It wasn't really intended to keep the Medicare program from paying for short-term rehab, but that was an unfortunate consequence of this. So just to be aware, there are some times where you might be in the hospital or a loved one might be in the hospital and they're not technically admitted. They're under observation. And then that Medicare benefit to pay for their short-term rehab is not going to be covered. So ask the question. Unfortunately, the decision of whether to admit somebody or to put them under observation is a medical decision. So although you can argue and you can push on it, you're not necessarily always going to be successful in getting somebody admitted, but at least if you know, you would know then, well, we don't want to rehab at a nursing home. That's going to be $15,000 a month. Let's figure out how we can rehab at home and maybe make it less costly for you. Myth number 6 is I am a veteran, so my long-term care needs are covered by the VA. The VA has a lot of benefit programs, but it's not an automatic that they pay for veterans' long-term care needs. There is aid and attendance, which Greg mentioned earlier. We are accredited with the VA to get aid and attendance benefits. And that's a benefit, it's a stipend, a monthly stipend that a veteran who served during specific war periods, so it's not 100% of veterans, it's only veterans who served during defined war periods, or the surviving spouse of a veteran who served during those defined war periods, could potentially qualify for a stipend if their assets are below $150,000. That's excluding their house, so we don't have to count the house in that. And their health expenses, like if they're paying for a home care person to come in or they're paying for assisted living, if those expenses either come close to or exceed their monthly income, then they can qualify for this stipend. It is just a stipend. It doesn't pay for 100% of their care needs, but it helps. It helps to pay for that. So it's a valuable benefit a lot of times for assisted living, and because Medicaid in Connecticut does not pay for assisted living for the most part, or if they have somebody coming in to the house and they just need, you know, some extra money to help pay for that caregiver in the house. That's for an ailment that has nothing to do with their service. VA also has service-connected benefits. So if somebody has some sort of a disease or disability or health problem that was connected to their service, then that's a totally different process. You have to get rated by the VA, and they're going to give you a certain number of the percentage of how your disability is related to your service. And if it's more than 70%, then the VA does cover the long-term care of that person, of that veteran. I have one veteran right now who's in a nursing home, and we're seeing more and more of this where veterans are severely disabled because of the effects of Agent Orange. And so we're seeing more and more service-connected veterans come into the picture because the Vietnam veterans are getting to the age where they're entitled to Medicare and Medicaid. So if you are a veteran and you have any sort of ailment, I would recommend that you do contact your local state representative's office to make a claim and see if you can get any service-connected rating. And that can always change too. As things change, you might be able to increase the rating as well. Like I said, if you get over a 70% rating, that's when all the care is covered. But before that, there might be some other benefits that you can get from the VA as well. Myth number 7 is life insurance policies are not counted when determining the value of my estate for Medicaid or estate tax purposes. So again, when you're applying for Medicaid, there's a certain financial threshold. You can only have a certain amount of assets. If you're a single individual, that amount is $1,600. You have to spend down your money to $1,600 in your savings account, bank account, in order for the state to say, okay, you're going to qualify for this Medicaid benefit, which is a valuable benefit because nursing homes, as I mentioned, are about $15,000 a month. Home care can be anywhere from a few $1,000s if you just need a few hours a week, up to potentially $12,000 a month for a live-in caregiver. So it can really deplete an estate very, very quickly if you're privately paying for that care. So if you're a single individual and you have less than $1,600, you can apply for the state program. In Connecticut, Medicaid pays for home care and it pays for nursing home. So in the continuum of different care options, you start with home care. Sometimes people sell their home and move into an independent apartment, which might have some amenities that help them. Then they can move on to assisted living, which have a few more amenities. There's memory care, which is also often a part of an assisted living community. And then there's nursing homes. So in Connecticut, if you're looking for the state to help pay for any of your care needs, you're either getting that at home or you're getting that in a nursing home. If you can afford the room and board of an assisted living or an independent, you potentially could get Medicaid, the home care program, in the assisted living. But the state is not going to pay for the room and board, which could be $4,000 to $8,000 a month. So you have to have a pretty significant income to be able to afford that room and board. But when you are a married couple, it's a little bit different. You don't have to spend down to $1,600 because they recognize that there's two people in this equation, and one of the people might still be at home and need money to continue to live on. So there's a more complex calculation if it's a married couple to determine if you qualify financially for the Medicaid program. Essentially, they take all of the assets that you own. As I mentioned earlier, everything's added up together, whether it's in one spouse's name or the other or joint. We take out the house if you own a house because that's an excluded asset. And then they add it all up and they divide it in half. The person who is qualifying or trying to get qualified for Medicaid has one half, and then the other person has the other half. The person who's qualifying for Medicaid now has to spend their one half down to $1,600. The spouse gets to keep their half up to $140,000. So everything else has to be spent. And when we're adding this all up, one of the things we have to include in that is the cash value that's in life insurance. And it's an asset that a lot of people don't think about. They don't really think about it as part of their estate because they're not really tapping into it. But it's important to remember that the cash value in a life insurance policy is part of the calculation to determine whether you can qualify for Medicaid. And if you have life insurance that has cash value and you want to try to qualify for Medicaid, you might have to cash that in and use the money before the state will allow you to qualify for Medicaid. This is a reason for asset protection planning. Oftentimes, if we're doing an asset protection trust and a 5-year look back plan, we might want to pull the life insurance into that so we can protect that death benefit and not have to cash in the cash value when and if someone needs to apply for Medicaid. Life insurance, the death benefit is also included for estate tax purposes. Right now, very few people have to worry about estate taxes. The estate tax exemption is currently $12.9 million per person, both federally and in Connecticut. I don't know what Vermont is, sorry. But so essentially you can have almost $26 million and not have to worry about, as a couple, and not have to worry about estate taxes. That is scheduled to potentially go back down in January 1st of 2026. It's still only going to be probably in the 7 million range. So again, a lot of people won't have to worry about that. When I first started practicing in 1997, it was $600,000 was the exemption. So at that time, it was really important to know that life insurance was included in that, because somebody could have $1 million life insurance policy and all of a sudden they have a taxable estate. But now it's kind of flipped. It's more important to know what your life insurance value is, death benefit and cash value, if you're looking at trying to protect assets against having to be spent on your own long-term care. Myth number 8 is I can transfer my house to my children without penalty. And I mentioned earlier a couple of times that the house is not included when we have to calculate and do a spend down. And so I think that's why a lot of people think that they can transfer the house without having any sort of a penalty, because it's known as an exempt or excluded asset when you're calculating if you qualify for Medicaid. But this is untrue. So if you transfer your house to your children and then you apply for Medicaid within 5 years of that transfer, the state will penalize you from receiving Medicaid because you gave an asset away. And the 5-year look back is a national look back, except for California. They have their own plan, their 36-month look back. But for Vermont and Florida, where some other people are, all states have a 5-year look back. They all have slightly different rules in terms of how they determine the penalty. But in Connecticut, so say for example, your house is worth $600,000 and you transferred it to your kids, and then 3 years later you had to apply for Medicaid. You otherwise spent all of your money. You were below the financial threshold. You submitted an application to the state. The state's going to look back. When you apply, you have to submit 60 months of bank statements and fill out an application that asks you questions about whether you've made any transfers, where you used to live, where you currently live. And they're going to assign a caseworker to review everything. And then the caseworker starts a correspondence with you or with your attorney, whoever is helping you with the application, and asks a lot of questions. And they come back and they determine whether you're below the threshold and whether you gave away any gifts, if you gave away any assets. If you gave away any assets and there's no other reason for it, you didn't get anything in exchange, it wasn't because the child was living with you and taking care of you or any of the few exemptions that there are, then the caseworker is going to say, this transfer was an improper transfer. And so you're otherwise spent down, your money is all gone, but because you made this improper transfer during the look back period, we are going to penalize you. And that means we're not going to pay for your care for a certain period of time. The period of time, so they don't actually send you a bill or anything like that. They don't like assess a penalty in terms of dollars. They assess a penalty in terms of time frame that the state says, we're not going to pay for you for a certain period of time based on the value of this improper transfer that you made. So they take the value of the house and they divide it by the average nursing home cost. Currently, it's about $15,000 in Connecticut. So they take that $600,000, they divide it by 15. I don't know what that comes out to be, but however many months that is, that's the number of months that the state doesn't pay for your care. You're out of money. So at that point, you're kind of stuck. Who's going to pay for that care? In all likelihood, it's going to be the people that you gave the asset to. They're going to have to sell that asset or take the money that you gave to them and pay for your care.
Joan, before you go on to the next myth, I know some people, they give the house away to their kids and they say, well, I'm planning, to live beyond, the 5 years before needing it. Are there other cautions that you would give to somebody about having children own their house? Yes.
Thank you for asking, because we do this often. We do asset protection planning where we do gift the house, and we never know exactly what's going to come in the future, so we have to be prepared to undo it if someone has a significant health crisis in that 5-year period. So if, say, you have 2 children, 3 children, 4 children, if you just deed it to all of them, it's riskier if you need to get it back. So you have multiple people who now you have to convince you have to give this asset back. So that's one risk with just deeding it to the children. Our advice always is to deed it to an irrevocable trust, which starts the same 5-year period, 5-year look back. But there's a couple of reasons for it. One, you can name one trustee, even though all 4 children are the beneficiaries. So the kids are all going to still share the same amount, but you only have one person that you have to trust to give it back to you if you needed it. Even more importantly, because all of our kids are great, right? They're not going to not give it back to us if we need it. But if the asset is in the child's individual name and they get sued for any reason, that creditor could potentially take an interest in your house, which you're probably still living in. So this could be the kid gets into a car accident and gets sued because of that. The child gets divorced and is going through a lawsuit for the divorce, and the divorcing spouse decides that they want to take a portion of this asset that the child has. So there are things that are outside of our children's control that could come back to bite you if the asset is in their name individually versus in this trust. And then the other big one is the basis in your house. So if you've owned your house for a long time, you probably have a pretty low basis for income tax purposes. If you were to sell it, you have a $250,000 exemption for capital gains purposes, as long as you've been living in that house for 2 years as your primary residence. So say you paid $50,000 for this house and now it's worth $300,000. If you were to sell it yourself, you wouldn't have to pay any capital gains because you're allowed that $250,000 gain exempt from paying capital gains taxes. But if you take that house that's worth $300,000, but your basis is $50,000, and you give it to your kids during your lifetime, the kids take on your basis. When they turn around and sell it, because they haven't been living there for the last 2 years, they don't have that exemption. So they're going to pay capital gains taxes or whatever the difference is between what they sell it for and what the basis was. So putting it in the trust allows you to capture your $250,000 exemption. So if the house is sold during your lifetime while it's in the trust, you still get that exemption. And it also gives a step up in basis. So if you live in that house for the rest of your life and then the kids just own it after your death, they're going to get a basis that's equal to the value of when you die. So there's a lot of complexities to just giving it away. It's a lot easier to just sign a deed and say, I give it to my son and my daughter, but it could cause a lot of problems for them and for you down the road.
And Joan, that exemption is $250,000 per person. So for a married couple, it would be $500,000?
Yes. Yep. So myth number 9 is a living or irrevocable trust protects my assets from my long-term care expenses. This is another misunderstanding, I think, just because of the use of the word trust. The word trust is used way too many times for way too many different things. A living trust or revocable trust is used for probate avoidance. So if you have a revocable trust that you set up, you probably did it for probate avoidance. And it might not say revocable trust in the title. So if you do have a trust and you don't know if it's revocable or not, one of the things to look at is, are you the trustee? Are you the beneficiary? Does it have a term, a section in that trust that says, I have the right to amend or revoke this trust? All of those are indications that it's a revocable trust and it was done for probate avoidance only. Because you are the trustee and you are the beneficiary and you have the right to amend it, you have too much control over that trust. So it doesn't protect the assets at all. If you need long-term care down the road and you try to apply to the state for Medicaid and they see that you have a revocable trust that has your investment accounts and your house in it, they're going to say, go get that money. Go get your money that is owed to you and use it first, and then come back to us if you don't have any money left. If you set up an irrevocable trust, which is what we would do for a 5-year plan and put the house into it, you are not the trustee, you are not the beneficiary, and you don't have the right to revoke that trust. So that's enough. You've given up enough control over the asset that you put in that trust that the state says, okay, we see it's not yours. And again, as long as it's been 5 years since you made that transfer, it doesn't have to be counted as an improper transfer, or you don't get penalized for it. But revocable trust, completely yours, and the state will expect you to use any money in that revocable trust for yourself. And it's not to say that they don't have any use. The whole point of the revocable trust is you pull assets out of your name so that when you die, there's nothing for the probate court to handle. Probate court only has jurisdiction over an asset that is in an individual's name. So the reason to set up a trust is you don't want any assets in your own name when you die, just so your family doesn't have to go through the probate process. They can step in as successor trustee and manage things more quickly than they could if it was in your individual name. If it's in your individual name, they first have to go to court, get appointed as the executor. They have no use or control of that money until they get appointed by the court. So sometimes that lag time can cause problems, especially if you have a business that you're running or something really needs to be managed on a daily basis. And you can't wait the 6 or 8 weeks that it might take to get appointed by the probate court. Another reason to avoid probate is if you have real estate in multiple states. Because even though the state of Connecticut's probate is not that terrible, it doesn't cost that much, it's not that time consuming. If you also have a property in Florida or a property in Vermont or a property in New York real estate, your family would also have to probate there as well. And that just makes it too costly, too time consuming. And there are particular states where you absolutely want to avoid probate, including Florida and New York, and California, where I used to practice. Those are states that it is very time consuming and costly to have to go through probate. So almost everybody there has a revocable trust to avoid the probate process. And myth number 10 is, if I do nothing, the state will take everything. I hear this almost on a daily basis too, that people don't want the state to take all their money. And the state doesn't take your money. The state just expects you to use your own money before it will pay for you. So if you do nothing, don't do any asset protection planning, the only thing that potentially could happen is there may not be anything left for your kids or your beneficiaries to inherit, but you will get the care you need, whether you are paying for it because you have the money or you run out of money and you apply to the state for Medicaid, you will get the care that you need. So, a lot of times people come to me, they want to protect their assets, but the number one question I have for them is having your children inherit some money a primary goal of yours? If it's not a primary goal, if your kids are doing fine, you don't feel the need to leave them anything. If you use it all up during your lifetime, that's fine. Then you don't really need to do any fancy asset protection because you're going to get the care you need. The state is never going to take all of your money away. Like I said, they're just going to expect you to use it on yourself before they're going to pay for your care. But once you do use it on yourself and you've spent it down below those thresholds, the Medicaid program will pay for you in either your home care or a nursing home. And that's it.
Well, thank you very much, Joan. I appreciate all of that useful information. I think there are a lot of tips in there that are interwoven with the myths and misconceptions that are very important for all of us to understand and make sure to know. The contact information for Joan is on the screen. We'll also include it in the notes for this video if you're watching the recording. But certainly if you think of a question afterwards, you're welcome to contact Joan, or you can contact our office at hello@hiwealth.com. In addition, Joan mentioned about the importance of the ownership of life insurance. And how it impacts your estate. If that's something that you would like to have a life insurance review to take a look at your existing policies, I'll be happy to do that as part of our review. We offer that with a complimentary consultation. And again, you can schedule that by going to hiwealth.com or emailing us at hello@hiwealth.com. Well, Joan, I don't see any further questions. And again, if you have a question, you can reach out to Joan directly, or certainly can reach out to our firm at hello@hiwealth.com. We thank you for taking time out of your day to join us, and you will be receiving a link to the recording of today's session in the next couple of days. And feel free to share that to those that you think would benefit from the information that we shared today. So thank you again, and we'll look forward to seeing you at our next Financial Power Hour.
Thank you all. Thanks for having me, Greg.
You're very welcome. Thanks, Joan.